First of all, let me thank the host University of Miskolc and the other organizers for hosting such a pleasant conference. And I have to say, secondly, I'm glad that my presentation is just before the lunch break, because from my experience, the hunger keeps the audience awake, and I will keep the success. On the other hand, also impatient, so I will hold to my time frame for sure. So, what's the content of my presentation? You can see something, and my presentation I can divide on two parts. Firstly, I will speak mostly from theoretical approach, and after that, I will try to point to some problems in practice. So, contractual system in Slovak labor law, I will try to focus on specific methods of regulation, relationship between the labor code and the civil code, limited extent of contracts in labor law, and I'm really curious if it's only in Slovak Republic or if it is also in different countries. And from the practical view, self-employment. That should be the peak of my presentation, because I will try to tell you two stories and illustrate how absurd may be the legal interpretation on one case in a different area of Slovakia. So let's move on. This is the basic. Contractual system, the Slovak Republic, specific methods of regulation. Specific method of regulation is something that point to separate branch of law, of labor law. Of course, besides the historical approach and historical tendencies, labor law has got in whole countries specific subject of regulation, employment relationship. In our country, it's dependent work and legal regulation dependent work. But why I point to a specific method of regulation? Because something's different in labor law comparing with public law and private law. Public law is made mostly by mandatory norms, private law by dispositive regulation. Of course, public and private law got both of norms, but as I said, in public law prevails mandatory norms, in private law dispositive regulation. Our labor code is based on third category, and from theoretical aspect we call it relatively mandatory norms. As a matter of fact, I do not know why mandatory relatively, because we can say also the relatively dispositive regulation, it's the same. The important is the first word, relative. I will quote our paragraph section 1, paragraph 6 of the labor code. In employment relations, the terms and conditions of employment and the working conditions of an employee may be regulated more advantageously than this law or other labor law regulation provides, unless this law or other labor law regulation expressly prohibits it, or unless it follows from the nature of their provisions that they cannot be deviated from. I underline terms and conditions. So, all labor code is based on these relatively mandatory norms, on maximums and minimums. Really nice example, maximum working time and minimum, for example, minimum wage. So that's the standard. It's really easy to understand, but still it does mean some practical problems. I choose, for example, period of notice. Maybe this is not the best example, because I found a couple of minutes ago that I pick up the period of notice for an employee who is given notice, but this regulation is pretty the same if the employee is who initiated the termination by notice. Important things shall be at least. What does it mean? How do you read it? Normally, you read it as a normal dispositive norm, so at least we can conclude more than 2 or 3 months. Can we conclude period of notice for 6 months for employee, 7 months, 1 year, 10 years, etc.? No. because it sounds absurd. But can we go higher than the minimum? For employer, for sure, because it's something in favor of the employee. And for employee, if employee is initiating, we need to read this specific article in accordance with relatively mandatory norms. Is it a condition in favor of an employee if we prolong the period of notice? Not. So, but on the other hand, we cannot just burn down freedom of contract totally. So, what if employer and if employee agrees, okay, if you initiate the termination of contract by notice, I mean you employee, we will conclude the period of notice for 1 more month or 2 more months, and it will be balanced with special wage or something special I'll give you. And this thing, I think it is in accordance with relatively mandatory norms, and it is accordance with contractual freedom. What is the point of all of this? Relatively mandatory norms are strict in labor code, and the whole idea is not bad to put minimum and maximum, but sometimes we try to protect the employee even against his will. And the freedom of contract in Slovakia is really small. It's really modest. Maybe I will skip this. I will return to that. Speaking of limited contractual freedom, numerous clauses of contracts is what does it mean? It means limited extent of contract in Slovak labor law. We have such a sentence in labor law: contract according to the relevant provisions of labor law is concluded as soon as the participants have agreed on its content. From my perspective, it doesn't say anything important. Once you agreed with the content of the contract is concluded. But our Supreme Court sees differently this sentence, and sees it like this, that you may conclude only such a contract that is written or mentioned in labor code or in different labor regulation. You cannot conclude any different contract from it. And this is really strict, and make also some practical problems. For example, I wrote here a recruitment allowance agreement. It's a typical agreement. The employer will give some budget of money to the employee and ask him to stay like for 5 years, and if not, you need to return the money. I think it's fair agreement between employer and employee, but according to the limited choice of contract types, it's forbidden. And for example, redemption from the period of notice is not a big deal. The third point I would like to discuss with you is relationship between the labor code and the civil code. I will continue speaking of the limited contractual freedom in Slovakia. Firstly, I said numerous clauses of contract or relatively mandatory norms, and we continue with really a limited extent of the subsidiarity of the civil code. According to the Slovak law, unless this act, I mean labor code, provides otherwise, in the first part, the general provisions of the civil code shall apply to legal relationship under paragraph 1, and it means individual employment relationship in a connection with performance of dependent work of natural persons for legal persons or natural persons, and so on and so on. Important are words general provisions. So subsidiarity applies to general issues such as definition of natural person, legal acts, not to the part, about the contract, and so on. So what are the consequences? The consequences are the several typical civil law instruments are excluded because they are not regulated in the labor code, and the subsidiarity of civil code is forbidden. Why is it such a strange situation in Slovakia? We need to look at this also by historical approach. We had a labor code as a Czechoslovakia in 1965, and this labor code was totally separate from civil code or from any other regulation. So there was duplicity of definition of legal act, duplicity of definition of legal person, and so on and so on. So typical instruments of civil law or typical elements of civil law were also in labor code. In 2001, our legislator decided that we will adopt a new labor code, and we will cut down this duplicity. Good idea, no problem with that. So they adopt a new labor code, 2001, and they give a whole subsidiarity civil code to the employment relationship. So that was the point. But the legislator and the practice found out that it's not a good idea, because after a while some civil instruments, and I can speak mostly about contractual penalty, were part of employment relationship because of the whole subsidiarity and civil code. So the legislator decided to reduce subsidiarity of civil code only to general part. But the legislator forgot that there are certain provisions that needs to be used also for employment relationship, and these provisions were back then in 1975 were cut down because of duplicity and were never put back. Even the subsidiarity was reduced only to the general provisions. What does it mean in practice? I will stand by the end. Default interest, something totally in common. Once you have to pay, you get the interest according to the special regulation. Interest is regulated by civil code. It's not in labor code. It was back in 1975, and you cannot use subsidiarity. So some courts take decisions that statutory interest, in the event of debtor's delay, are not allowed in the labor relationship because of the lack of subsidiarity of civil code. It makes no sense, but this is one kind of approach. It's not the majority approach, because majority will decide also about the statutory interest, but do not think why yes or why not. The first example is about set-off. So set-off is as a way of termination any relation. Financial relation is forbidden in legal relation. So this also makes some problems, not as big, for example, as this default or this interest, but for example, if employer immediate terminate the contract, or not immediate, it's not a bad example, terminate the employment contract by notice, by organizational reasons, and he pays several allowance to the employee, and then employee challenge this termination as invalid, the employer needs to ask for this severance allowance what was paid by separate action in front of the court, because if he lost, he cannot set up what I need to pay you because of invalid termination, and I cannot set off it against the severance allowance I already paid. Okay. To To this point, no, really? What does it mean? We can handle this situation, and we can handle it also by theoretical approach, by analogy of law. So if some regulation or some provision would be obsolete, we need to use analogy of law. And we can use analogy of law also because of the interest. We can look back at the Labor Code of 1965. So no regulation is needed. Okay, I promised you the peak of my presentation, self-employment. I will give you some background. Typical company of limited liability. One person is one partner who is also general meeting, and he is also statutory body and is also employee. First situation, this statutory body, he was an employee. He was the person who is only person as a partner of this company, limited liability. He was a statutory body, and he works in his shop. He sells the things, really small shop in small village. And labor inspectors came by, have a nice chat, and then set him a fine. Why? Because they told him that this is typical dependent work, and if you are working dependent, you need to work under labor regulation. You have to have employment contract or any other contract, and if not, it's illegal work with a fine at the minimum 2,000 euros. Another situation, the same. Company with limited liability, one person as a statutory body, one person as a partner, and he employs himself and get injured. And as he get injured, he asked for social benefit from the social agency, and social agency told him, no, this is not dependent work. Social agency gave him back all the contribution for like 7 years, because it is not dependent work, because you are the employer and the employee at the same time, and this is a lack of subordination. So totally the same lost-lost situation. Once you do not have employment contract, you are fined by illegal work. Once you have an employment contract and you ask for social benefits because you were an employee and you paid your contribution as you should have, it's not a dependent work. So, and at the end, because I've got my time frame, the most popular slide. Thank you very much for your attention.
So Marcel, Dolobáč studies gave me an insight into the typical characters of current labor law in Slovakia. On the basis of the study, I can conclude that some institutions of labor law are regulated in a similar way. In this speech, I would like to draw the attention of those present to just a few of the differences. The main difference is that the Hungarian Labour Code doesn't define the notion of dependent work. The delimitation is based on various guidelines that Sára was mentioned in his first speech, and judicial practice in Hungary today, and the main aspects of which are similar to those Slovak of labor law we can see on the slide. Similar to Slovakia, Hungarian law also regulates sanctions for illegal work. We have a different act. This is the Employment Supervision Act, which entered in force 1 year ago. And the legislators said that the new law motivated by the need to reduce illegal work. Sanctioning increasing penalties can be a strong incentive to reduce undeclared work, illegal work. However, the level of penalties should be set in such a way that it is not counterproductive, does not substantially restrict the economy or increase the competitiveness of honest employers. In spite of, there are a lot of sanctions. We will see how many sanctions are in Hungary. First of all, under the Employment Supervision Act, we have The first primary sanction is that the supervisor shall establish the employment relationships retroactive to 30 days from the date of the violation. It could be some other problems generate. This means that the employee will have at least 30 days of full-time general employment and corresponding social security status. Oblige the employer to notify the tax authorities. There is another act, which name is Sanction Act, and this is also state some sanctions. A special sanction is a labor fine that we have heard from Slovak labor law also, and this labor fine could be 75 euro to 25,000 euro, and I think it's very, very high, the measure of the fine. And the secondary sanctions could be, under the Employment Supervision Act, that if an employer employs without notifying the tax authorities or hires out workers without permission, he may not only be fined for labor, but also be excluded from receiving budget support. The next sanction could be that the Employment Monitoring Authority keeps a public record of the infringement and publishes it on its website. And it is possible to be removed from the register before the expire of the period for which the registration is required, if it pays 3 times of the amount of the labor fine imposed. So I think it's a very high fine and penalty for the employers. And of course, there is a tertiary sanction, and we can see that the taxpayer, it is the employer, classification institution, the National Tax and Customs Administration, in Hungarian name is NAV, examines on a quarterly basis whether a given taxpayer is classified as a trustworthy or risky. And there are 2 lists in Hungary. This is black and gray, and it's available on the NAV website, listing taxpayers with undeclared illegal employees and taxpayers with unsettled employment relationship. If a taxpayer is on the list of taxpayers with undeclared employees, it is considered a taxpayer at risk for 1 year. So these are the sanctions that the employers can get if they operate some illegal work. So let's see the methods of the legal regulation of labor law in Hungary. The new labor code, which is now 10 years, introduced a conceptual change, that intention being to increase the regulatory role of collective agreements. I think the collective agreements in the past 10 years that this have passed, this has not produced results, in my opinion, that this legislators' opinion said. In Hungary, the collective agreement can deviate from most of the collective agreement to the benefit and detriment of the employee. We call it absolute dispositivity, and there are 3 exceptions: cogency, unilateral relative dispositivity, and bilateral dispositivity. You can see on the slide. The next question that my colleague mentioned in Slovak labor law is the relationship between the labor code and the civil code. The labor code expressly provides for the application of certain provisions of the civil code to only the legal notices, In addition, it also refers in a few places to the application of the rules of civil code. The earlier case law allowed the applicability of the civil code on the basis of other principles, namely that in labor law the rules of civil law are generally applicable provided that they do not conflict with the rules of principles of labor law. And in my opinion, this kind of practice wasn't so bad for the employees. We have heard a lot of things about Hungarian employment contract, so I will jump this slide, and I would like to say some words about a collective agreement connecting with my colleagues. In Hungary, a collective agreement can be concluded for a fixed or indefinite period of time, and of course can be terminated with 3 months notice. And in Hungary, that my colleague Attila mentioned in his speech, the collective agreement may be concluded by a trade union whose members in the employer's employment are at least 10% of the employees. And because of this rule, a trade union which has no employees in the employer cannot enter the collective bargaining process here that my colleagues mentioned in his presentation, in his publication. In Hungary, it's a usual that the collective agreement can be concluded local, multi-employer, and sectoral employer level. Only one sentences. I would like to show you that how many collective bargainings are in Hungary. In Hungary, the sectoral collective agreements are not common. The multi-employer is about 20 agreements, and at local level are around 1,000, but it's an official data. In practice, about a third of these are still in force, unfortunately. So in Hungary is the same, that the collective agreements are very low. And I saw the data in the last year. There will be 13 local collective agreements at national level. So thank you very much for your kind attention, and I hope that we will discuss it on the round table.